back to part 3 of the 4-part series, an introduction to governance for private SMEs and entrepreneurial businesses, and the latter one where entrepreneurs want to take their business to the next level. In the first session, we discussed the concept of governance and what it means and when you should consider it or take it more seriously, should I say, than a one-man show. And then secondly, in the second portion, we spoke about strategy and risk, which is fundamental to every business, but forms part of governance. It's one of the elements that's included in King 4. But you would not carry out a business not knowing what your strategy was. In the third section, we're now going to talk about directors and the liability you pick up or your fiduciary duties. The moment you sign that piece of paper that says you're a director of a company and it gets registered with SME, you now pick up the liabilities and fiduciary duties. It doesn't stop there because you can't hide behind that. There is a thing that has been introduced called prescribed officers, where you may not be registered as a director, but you essentially run the company or a major portion of the company. You could be then classified into that same category as a director and carry all that fiduciary duty. So please just understand where you operate, and please don't think, I haven't registered myself as a director, therefore I don't pick up the liability. You will at the end of the day, under the prescribed officer definition. What is required of a director? Firstly, you have to act in good faith. I think that goes without saying. Secondly, in the best interests of the company. And let me just stop there for the moment. Let's separate a director and the entity. A company is a separate legal entity. The job of a director is to ensure the sustainability of that entity. So it's in the best interests of the entity for the sustainability of that entity. So you cannot withdraw all the cash out of a company and allow a company to go under because it's not in the best interests of the entity. It may be for the shareholders, but you are worried about the entity as a director. And we'll come back in the last portion between shareholders and directors because it's absolutely critical in your governance process. So we said, firstly, good faith. You have to act in good faith, in the best interests of the company. And then thirdly, we're looking at you have to have, or you have to operate with care, skill, and diligence expected, reasonably expected of that job. What does that mean? It actually doesn't define it. My problem, or my warning to you is, if you end up in a court of law, you have a judge sitting in front of you who looks down and sees the name director behind yours. What do they think? What is expected? What is the image? What do people think? When you walk around town, say I'm a director, what do people think? They think you're intelligent, you've got business logic, you can read financial statements, you're going to act in the best interests of the company, and you're highly capable at what you do. It's the one profession that there is no exam that you write. You can't study for 7 years and come out, I'm a company director. There's no such thing. The IOD is starting to try and put some qualification in place, but it'll take time to gain traction. So the reality is, when you start working and you look up and see a director walking through the factory, you're dead scared because there is the most intelligent person you've ever seen from a business perspective. I'm not saying 5 years down the road you realize that they're not what you thought they were, but understand you've moved from there, and as you've grown through the organization or started your own company and bring people in, the perception of you is a director you're intelligent, you're capable, you've got business logic, you can read financial statements. And if you can't, you have a problem. You need to get your skills up to scratch. And particularly, I'm going to talk about financials, because you can't sit back and say, oh, I had a financial director. It's irrelevant. There are case studies available to show you that the board gets charged. They don't go and charge the financial director because it's expected of you. You don't have to understand IFRS. To be honest, no one does. That's why they have technical departments within the auditing firms to do that explanation. What you need to understand and have certainly a strong grasp on is, where does the money come from and where does the money go to? If I'm making huge profits, where's the money? It's got to have gone somewhere, even if it's just to ask those questions so that you can protect yourself. What is your defense? If you are able to demonstrate that, and we're talking about major decisions now that have put the company into serious trouble or put them under. Firstly, in taking the decision you took, did you take all reasonable steps to be informed? So, for example, if your sales manager comes to you and says, I'm going to double turnover this year, and you as a board member or even a CEO don't say, where are you going to get the turnover from? Which market segment? Which product? Which product are you going to displace? You can't just accept it. Because then if the company does go under, you haven't taken all reasonable steps to be informed. A non-executive director doesn't have to go and physically check, but a non-executive director has to have shown that they've asked all the right questions sitting on that board. Secondly, it must be rational and a basis of your belief that it's in the best interests of the company. So if your core competencies, for example, are very much into trading, you can't go and become a mining company or acquire a mining company and try and integrate it. Why? Because the core competencies of mining are totally different to those of a trading company. If you do take that decision, you have to show what steps you've taken to ensure that you've got the core competencies to ensure the success of that entity. Otherwise, you're putting your entity at risk. So that's your second. And then finally, there can be no conflict of interest. And we've seen this run through our SOEs at present. You cannot take a decision, for example, to give a big contract to somebody, and the somebody involved in that company happens to be your wife or husband or son or close relative, because that's a conflict of interest. You need to stand up, you need to say, I'm conflicted, and you need to leave the meeting and let the company decide without you. If you do those three things, you generally will be safe in terms of your fiduciary duties within a company. There's a whole lot more around this, but stand back, have a look, and say, do I know what the strategy is? Do I know what our core competencies are? Do I have these short-term actions that I'm monitoring all the time? Do I know what the risks are, and am I monitoring them? And then do I understand my fiduciary duties? And am I carrying them out in the best interests of the company? That's what's got to be in the back of your mind continuously.